If you've just tuned in, you're watching Newsnight with myself, Rofhiwa Madzena. Let's bring you this story now. Australian geodata science company Searcher wants the High Court to reconsider a ruling that halts its seismic blasting. Civil society organisations, the Green Connection and We Are South Africans lodged the legal challenge against the survey. Now this week, the Western Cape High Court ruled that Searcher should discontinue activities that are related to the seismic survey off the West Coast. For more on this, I'm now joined by Johan Lorenzen, who's the associate at Richard Spoor Attorneys. Many thanks for your time this evening, Johan. So we are told that there needs to be a reconsideration of a ruling to halt that seismic blasting. Perhaps furnish us with the reasons as to why.
Right. So we were in court last week on Monday on behalf of West Coast communities who have been engaged in fishing for generations, descended from both slaves and indigenous Khoi and San communities, and obtained an interdict against the seismic blasting on the basis that our clients aimed to set aside the entire permit because they were not consulted as they say they ought to have been. Searcher elected not to file answering papers before that hearing, which is perhaps one of the reasons why the interdict was granted. Last week, they filed an application on Wednesday seeking an urgent reconsideration, giving us 42 hours to file answering papers. We did so when we were in court this morning, and we're very pleased on behalf of the communities that the Western Cape High Court declined to set aside that interdict. It remains in place, and we'll be back in court on the 24th of February for a full hearing on the interdict and whether it will be extended even further.
Yeah, absolutely. And I'm glad you bring up the consultation process, because in Searcher heading back at the various developments that have happened, it was said that they didn't bother to consult the affected communities. And perhaps just elaborate for us why it would be important to make sure that everybody involved within the communities that would be affected by the seismic blasting, that consultation process would be crucial.
Right. So many of these communities are descended have long ancestries of fishing at a time when racism, colonialism, and apartheid limited their opportunities. These communities sustain themselves from fishing and form part of the cultural heritage of the Western Cape. I mean, imagine the Western Cape without snook. And so they sustain themselves from these fish and from their fishing activities, as well as from their relationship with the sea. And what is very clear from multiple experts is that the seismic blasting that Searcher intends to use to look for oil and gas under their sea would be highly disruptive to that environment and be very disruptive to their fishing and livelihoods. And so the communities, at a minimum, believe that they ought to be consulted to see what could be done to mitigate those impacts, or if those impacts are so severe that the blasting shouldn't happen at all. And none of these communities, it's now common cause, were ever consulted by Searcher. And so they assert their right to that consultation and insist that if this blasting is going to happen, you better consult first to make sure that their rights are protected.
Now, Searcher has indicated that the process has been unfair in that they weren't given enough time to respond to the affidavit that was put forward and really the responses that you all had put forward to the courts. Your response to that, they're saying it was simply an unfair process because they just didn't have enough time.
Well, they're, of course, entitled to say what they would like in court, and it's for the court to assess. We think the court quite correctly extended the interdict because we didn't think there was much merit to those claims. What became clear is Searcher refused to give undertakings not to start blasting pending the hearing of the court case. They refused to even indicate whether they were blasting until the day of the court hearing last Monday. So the communities were faced to go to court as quickly as possible. And it's the nature of urgent court that you always want more time and you always want to file the perfect papers, and that's just not the case in urgent court. Searcher decided instead of filing filing papers sooner, which would be the general practice, at least in the way we approach the law, they elected to file more comprehensive answering papers after the day of the hearing. We maintain that there's no merit to their contention that they didn't have enough time, and the fact that they were blasting that the harm that our communities are worried about was ongoing meant that the court had to intervene, which is, of course, what the court did. And again today, the court confirmed that they should not be blasting until we get a full ventilation of the issues.
What about the argument, Johan, that the seismic blasting could have some huge positive economic implications on those communities and perhaps even wider reaching should there be the discovery of some oil and gas? Those communities and surrounding areas could potentially benefit. What say you to this particular argument?
We say that we trust communities to make informed decisions about weighing the pros and cons that they'd be faced with. But the only way that they can be making those decisions is if they're consulted. So if it's indeed true that they'll be making lots of money, getting jobs and opportunities, then that's exactly what should be told to them in the consultation process instead of ignoring them and going ahead without them.
Brilliant. Thank you so much for your time, Johan Lorenzen, who's an associate at Richard Spoor Attorneys, talking us through the seismic blasting that's now been prevented for Searcher to do because communities have largely been unconsulted and, of course, their livelihoods are at risk should things go horribly wrong.